A very good morning to one and all. In today's lecture, we would be discussing about international law and chapter 2 of international law, that is the sources of international law. It is very generic subject that we would be discussing in today's video. So, before we start the sources of international law, we need to understand that the sources of international law has been given in International Court of Justice. Okay, so the International Court of Justice, there are certain articles which explain us about international, what are the sources of international law. International Court of Justice was established in June 1945 and operational from April 1946. The headquarters of ICJ is in Hague, which is in Netherlands. Now, when we start understanding the sources of international law, we would be discussing about Article 38 Clause 1 and Article 38 Clause 2. Article 38 Clause 1 consists of what are the sources of international law. Generally, the sources are very important because if at all any dispute that arises between two parties or two countries, the International Court of Justice has to take certain authoritative basis of law upon which they can give judgments. So these are the bases that we can consider. These are the sources through which the law justice has been provided if at all there is any dispute between the states. The first source under Article 38 Clause 1 is international conventions. The second source is international customs. The third comes the principles of law recognized by the civilized states, which are also called as the general principles of law recognized by the civilized states. The fourth one is judicial decisions, which are subjected to the provisions of Article 15(9). And as what I have stated is Article 38 Clause 2 is also considered to be the sources of international law, which is a Latin term, that is ex aequo et bono, which means according to the right and good, from equity and conscience. So these are the sources of international law which act as a basis and which aids the International Court of Justice to resolve the disputes that arise before in front of them between the two parties, two international parties. Okay, so these are the sources. Apart from these, there are some other sources of international law, such as the decisions given by the United Nations Organization, second, resolutions of international conference, decisions of municipal courts touching international matters, and the fourth one is juristic work. So these are additional sources apart from those sources which are being given in Article 38, and upon these are also the basis to resolve the disputes between the parties. Okay, now let's start discussing about each sources of international law. So we will start with international conventions. Okay, international conventions. What are these international conventions? Whether general or particular, international conventions are a set of established rules explicitly recognized by the contesting states. So these are the conventions. So before we international convention is considered to be one of the sources of international law, right? So before we understand conventions, it is very important that we need to understand three major terms. Okay, so the first term is treaties, next comes conventions, and the third one is protocol. It is very important that we need to get clarity on what treaty is. So treaties are generally an agreement between two or more countries. Okay, so it is a treaty. If at all any two or more countries sign about certain agreements, then it is called as treaties. But when two or more individuals sign, it is a contract. When states or the countries sign, it becomes a treaty. Okay, next is conventions. Conventions are special type of treaties. What are conventions? Conventions are a special type of treaties. For example, Vienna Convention. It is a special type of treaty. Okay, and the third one is protocol. Protocol is method of altering treaties. Generally, for example, when treaty is of a special type, it becomes a convention. And when you want some alterations or amendments or additional addition in the conventions, then it becomes a protocol. Montreal Protocol, Kyoto Protocol. These are the protocols. The protocols is a method of altering treaties. So it is very clear, I guess. Treaties are an agreement between two or more countries. Conventions are special type of treaties. Protocol is a method of altering treaties. Okay, so this is what international convention talks about. Now comes where are the treaties defined? So we need to understand, right? So every term should be defined properly, then or else there will be a question like, where do you find the definition of treaties? So when you search various conventions, when you read various conventions, they are all based upon these treaties, and the definition of treaty has been given in Article 2 of Vienna Convention, which was been signed in the year 1969. What does Article 2 of Vienna Convention states? Article 2 of Vienna Convention states that a treaty is an agreement whereby two or more states establish or seek to establish relationship between them governed by international law. So it is generally two or more states who seek to establish a relationship between each other, and this relationship is being governed by an authority which is known as international law. So any agreement between two countries which are being governed by international law is considered to be a treaty according to Article 2 of Vienna Convention. The second set is Article 3 of Vienna Convention of 1969, which extends a bit, where it states that other subjects of international law also conclude treaty. For example, in other subjects as in international conventions, international treaties, Kyoto protocols, and other organizational meetings, that the universal conferences which are being adopted. So these are also they also come under the umbrella of Article 3 of Vienna Convention, which states that even those can be recognized as an source of international law. Now, the second type of source that we talk about is international customs. Okay, so what are these customs? Customs are generally the usage which have taken the force of law. So it is an evidence of general practice of law. Okay, and customs are the usages that take the force of law. And what are usages? Usages are international habits which haven't taken the force of law. So basically, how the customs are evolved? Customs are evolved into, first thing, it is a usage or a practice upon by a community or a state. For example, when we talk about international law, we will be discussing about a state. A country practices certain customs. Okay, so these are the general customs that you see all over the world. These customs are uniform practice. Okay, so when the practices are uniform, and when these practices, so in order to make a custom, there are two major points. Point number one, there must be a uniform practice to call it as a custom. Second, such practices is obligatory. Obligatory as in there must be an opinio juris. What do you mean by opinio juris? Opinio juris states that there must be an obligation upon the parties, and it should be recognized that the customs are to be recognized, that these are uniform in practice and these are obligatory in nature. Then only it is being considered as customs. Now we will discuss about the general principles of law accepted by the civilized states. What are these general principles of law accepted by civilized states? These are general principles as in right to equality. Right to equality is a fundamental right? Pacta sunt servanda, this we have studied in the previous video, where I stated that pacta sunt servanda means an agreement which has been entered by two parties. There must be good and in a bona fide nature, right? So whenever you sign a contract, when when two parties come together and they sign a contract, they agree upon a particular decision, and then they should be binding upon it. So pacta sunt servanda is a general principle. Even if you go to USA also, this is a general principle. Like the Indian Contracts Act, what we read, offer, one person gives an offer, the other person accepts it, then it becomes an agreement, and when it has been enforceable by law, it becomes a contract. So this is general principle. Even if you go to US, you will find the contract to be this only. There will be an offer, there will be an acceptance, and then there will be an agreement and enforceability of law. So these are the general principles. So what is general principles? Which apply within all systems of law, which is recognized within all systems of law. Matlab means everywhere in all the countries this principle has been recognized. So for example, as I stated, pacta sunt servanda. Next, no man can be judged on his own case. This we will study in administrative law. The third one is right to self-defense, right? If at all anyone comes and tries to kill you, then you will try to self-defend yourself. So right to self-defense is also the part of general principles of law. The other one is res judicata. So these are certain general principles which are being recognized and which are considered to be the sources of international law. The fourth source and the major source of international law, the final source that we will read today is, the fourth and the final source that we will read today is about the judicial decisions and juristic work. So, judicial decisions basically are subjected to the provisions of Article 59 of International Court of Justice. What does Article 59 does state? It states that the decisions of the courts have no binding force except between the parties and in respect to that particular case. It states that if at all two or more parties come together in front of International Court of Justice to seek justice for the countries, then the decision which has been given by the International Court of Justice is binding only upon those two parties, first thing. Second, what you need to remember is that the binding force of the International Court of Justice on these parties are only subject matter to the case that is being brought in front of the court. Understood? So first thing is, it is binding only upon the parties. For example, India and Pakistan has a dispute, okay, and they go to the International Court of Justice to seek justice, right? Then the decision which is being given by International Court of Justice on a particular issue will be binding upon India and Pakistan only, but not on Sri Lanka or Bhutan. Okay, so this is what the provision says. Second, International Court of Justice do not adopt the doctrine of precedent. International Court of Justice do not adopt the doctrine of precedent. What is precedent? Doctrine of precedent? It is also called as stare decisis. It is a Latin term which is used for doctrine of precedence. Stare decisis means a legal principle of determining points in litigation according to precedents. Okay, a legal principles of determining points in litigation according to the precedents. Apart from this, you also have uniform decisions of the municipal courts as an evidence of international customs. Uniform decisions which are being given by municipal courts as in the domestic courts, the courts within the country. If at all sometimes what happens is the Supreme Court of India will take the international customs into consideration and then they give the decisions. They will take international conventions also into consideration and then they will give decisions. So even the International Court of Justice, if it fails to render justice upon the sources and if it doesn't find any proper source, then they can take this into consideration, that is the decisions which are being given by municipal courts as an evidence of international custom. Apart from this, the last and the final source that we will discuss is of juristic work. So basically these sources are actually being used in order to resolve the disputes between the parties, and these are used in a systematic manner. Like if at all any dispute between the parties or between the states come in front of International Court of Justice, then first they will take into consideration of international conventions, and if at all they fail to resolve the issue, then they move on to international customs. If they fail to resolve the issue based upon international customs, then they try to apply the general principles of law. If at all they fail to resolve, even then they fail to resolve, then they depend upon international decisions which are subjected to the provisions of Article 59. And if at all they fail to adopt that, then they depend upon the Latin term what we have explained or seen in Article 38 clause 2, that is ex aquino et bono, which means the decisions are to be taken on the basis of just, equity and good faith. So these are the basis through which the International Court of Justice resolves, and these are the sources of international law. Thank you so much for patiently listening. If you like it, please like, subscribe and share, and please don't forget to click the bell icon. Please provide any suggestions that are required and any additional information that I need to add in the comment box. Thank you so much.